I'm Debbie Moraes. This is Legal Matters, the program that's been designed to address the critical, sometimes contentious issues that are facing consumers and businesses today. It's legal information, it's practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. We always want to thank Bazar Grasso law firm from East Providence, who sponsors this program, gives us information and insight. Attorneys Jacqueline Grasso and David Bazar. Jacqueline's not with us. Welcome, David.
Thank you, Debbie.
So today our topic is, let's make a deal or not. If you're innocent of a crime, should you ever plead guilty? You'd think immediately, perhaps, no, why would you? That's not the truth. But at some point, there are incentives that at times appear to be so great that it would actually seem difficult to stand on your principles. And then on the other side of it, when should or should you ever settle a case outside of a courtroom rather than sue, go to trial, perhaps even lose? Imagine that. So what do you really know about making these choices? We thought it would be a good idea to check in with our legal eagle here and find out. There's the criminal level and the civil level. So let's start with the criminal level, David. It's accurate, I guess, to say that you could plead guilty ahead of time or you could plead guilty and be convicted later. Is there really an incentive? Is there ever a time when you should plead guilty? When?
Well, first of all, let's just do a little bit of difference between criminal and civil, because we're going to talk about both.
Good.
So criminal charges are charges brought by the state against you for some wrong that you committed, whereas civil suits are brought by an individual against a person for some damage that has been caused to them, and usually those damages are awarded in monetary terms. So in a criminal case, when I do some of that, if a client came to me and said that I didn't do what I'm charged with, oftentimes those are cases that really need to go through the process and probably to trial, because it's very rare that someone who didn't do something is offered something so good that they just want to give up their right to a trial and throw in the towel, so to speak. But there are times where that happens, and for instance, if you're charged with something fairly serious, and they're offering you a deal such as a not guilty filing, which is the case is reduced to a misdemeanor from a felony perhaps, or if it's just a misdemeanor in the first place, and you're not admitting to guilt, so you're maintaining your innocence by saying not guilty, and then the case is filed, which means it's put away for a year. If you stay out of trouble for the year, then the case is thrown out. So it's giving up the right to go to trial, to have your innocence, vindicated and shown, but in the other hand, you don't have to go through that whole process, and you've been able to maintain your innocence.
So I guess in one way, it certainly makes sense that if I don't feel that I was really guilty of that traffic fine or whatever, I'm likely to say, this makes my life easier, I'll sign the check, send it in. I might not like what's going to happen to my insurance later on, and maybe by the time I sign that check, I'm saying I'm guilty. I just don't want to go before the judge and save myself some time and added grief. But isn't it true that at times, even if you had a client who said that he's innocent, if he didn't have a really good case, perhaps that prosecutor might say, listen, let's save us all some headaches, Mr. Attorney. Let's just plea this out or have him plea and we'll give you less of a sentence, almost as if there's a reward for pleading.
Well, and there can be. As cases proceed through the criminal process, and traffic matters aren't usually criminal, they're civil, civil violations.
Sorry about that.
That's okay. But as we proceed through the criminal case, there can be cases where there's some evidence that something was done that wasn't correct. The prosecutor may have some incentive to offer a deal, as you call it, because they might not be able to prove their case beyond a reasonable doubt, which is the standard of proof that they have to rise to. So they may offer a good deal. The person who really doesn't think they did anything wrong may face some potential criminal charges that they don't want to have to fight through the whole thing, so they may want to agree to this good deal that's put on the table. There's other ways of doing that. Some judges will let you enter into what's called an Alford plea, which is where you say, listen, I'm not admitting that I did anything wrong, but I'm choosing not to fight this case, so I'll accept the consequences, so to speak. So the offer might be probation on a case that might have serious jail time. You accept the fact that you're not going to fight the case and you're given the probation and you live with that consequence.
Before that would happen, David, would you, as, say, an attorney for the person who's been accused of a crime, would you know in advance that if he were to take this position, what his consequences could be, would be, might be, so that you could advise him?
Sure. And so when you're charged with a crime in a felony situation, it's either through a grand jury indictment or through an information filed by the Attorney General. So once the charges are presented against your client, you know exactly what the maximum consequences are. You know what generally happens given your client's background and prior criminal history, of any. So you know what the client is looking at if the client goes through a trial. And this is maybe a little bit of what you're saying. When it goes through a trial and goes to a jury and the jury finds your client guilty, now the sentencing is in the judge's hands. And depending on what judge you have and the consequences of what your client did and has for a past history, there may be different levels of punishment that that client may face. But you have a good sense of what that is prior to going all the way through to a jury verdict. So what would happen is there's pre-trials and other opportunities to speak to the Attorney General and find out what they might offer so that they don't have to face their high burden of proving something beyond reasonable doubt and the possibility that they might not be able to do that. So you can say to your client, look, this is what's being offered to you. This is the possibility of what you might face, which is much more serious, and you can discuss what the right answer is for the client. In many instances, the client may have done something, maybe not exactly what's charged, so there are lesser included offense issues and all of those types of things. So there might be a lot of good reason for a client to accept a plea at some point before you go all the way to a jury trial.
Clearly, it makes sense that you can help prep someone going through this process. I can't imagine someone not wanting a lawyer if they had a criminal case against them. But if they ever did, is there anything that you could suggest that they should at least ask of the judge, or ask at all before they decide whether to say guilty, not guilty?
Sure, and there's a couple of things that you need to know. Obviously, if it's a felony, there's some serious consequences to pleading to a felony or being convicted of a felony. They call those the maybe forgotten civil disabilities that people face once they've been charged with a crime, or when you're incarcerated, you lose certain rights. So they should know about all those rights. I would never, and we have in our state and in the country, you know, the right to representation. So if you can't afford an attorney, a public defender, or if there's a conflict with the public defender's office, an attorney will be appointed for you. We've heard those things said in TV situations. So I would never want a client to try to handle a felony case on their own. Oftentimes, a misdemeanor which is handled in the first instance in district court, a client will go in and they might have a case where it's not a very serious charge, but you know, there is a criminal charge nonetheless. And the judge actually, if they want to plead to it, will go through certain rights with them. The right that they have to a trial, the right they have to a trial in front of a judge in the first instance in district court, and to appeal to the Superior Court for a jury trial, and all of their constitutional rights, the right against self-incrimination, the right to make the state prove its case beyond reasonable doubt. They also will tell you that there are certain crimes, misdemeanors, that DUI, for example, driving under the influence, that if you plead to that, a second offense will have enhanced penalties, so that the first offense might be a 3 to 6 month loss of license and things of that nature, but a second offense may have mandatory jail attached to it, or possibility of jail attached to it. So those things are explained. And then, of course, there's immigration consequences to pleading to certain things. So the judge will tell you to go, they won't tell you what they are, but go consult with an attorney if the consequences might apply to you.
And if someone were likely to want to go to a trial, do they actually, I think you started to address this, do they have a choice about whether or not they go to a judge, or whether they go to a jury and then a judge, then a jury if they appeal, etc.?
So the misdemeanor cases, yes. You have a choice to say, I waive the right to a jury in the first instance and I'll try the case in district court before a judge. And I almost call it like a free bite at the apple, because if you lose in front of that judge, you have a right to appeal and then have your jury trial in Superior Court. If it's a felony, it goes to Superior Court in the first place, and in Superior Court, you as the defendant have a right to a jury trial. You can waive that right to a jury trial, so if you're sitting in the case in front of a judge who you think will understand your case better than a complicated case that a jury may or may not get the nuances of, you may want to waive the jury in that case, but you don't have that same right like you do in district court, where you waive the jury, have the judge try it, the judge finds you guilty, and you say, wait a minute, I think I want that jury now. You don't get the second bite at the apple in that case.
Good to know. When it comes to the number of cases that a prosecutor might have in the queue, we often refer to them being able to indict a ham sandwich.
Yep.
Knowing that they might have a queue, is it ever likely that you'd take a look at that as a defense attorney? Say, would you ever take a look at, know how many cases, or have a sense that they're really backlogged, so gee, it might be better if we plead this, because you might find that the prosecution doesn't really want to try this case, they just as soon tuck this away nicely, neatly, and expedite it. Does that ever work?
Well, I don't think that the caseload particularly weighs in a lot on what decisions are made in trying to do a plea bargain or not.
Okay.
There are a lot of other factors that are, such as how strong the case is, what chances you have as the defense attorney of obtaining an acquittal. A prosecutor might look at what is the seriousness of the crime, what is the person's background, what has happened before, and what difficulties do they have in presenting their case to a jury to obtain a guilty verdict. So those are the more important factors that we'll look at, and the AG's office will look at in determining what might be offered for a plea deal, so to speak. But, you know, maybe a prosecutor, as he or she may look at her case, might determine, you know what, this case isn't that important, I have a lot more important cases, and I'll give something that I might not otherwise give in the case because of their caseload, but I don't think it's a very important factor.
Okay. And in looking at or reading some of the information about how cases are pleaded, then do you find that it's true that if someone does plead, that they have a sentence reduction of at least two, quote, at least 2 levels and sometimes 3 levels? And depending on what else is going on in that person's life, recently I read of a case where a woman knew that if she didn't plead, she would probably be found guilty and go to jail and never see her baby daughter. So is it really true that 2 to 3 levels might actually make someone say, I'll take the guaranteed small amount of time rather than, if I'm found guilty, I'll end up there for the rest of my mortal life? How does that work?
So when you talk about levels, you're really talking about federal court, because they have these sentencing guidelines with all these factors that go into the guidelines and the levels of, you did this, this, and this, and you have a prior of that, and you didn't accept responsibility, and you made us go to trial. So they step up levels in federal court as to how severe your sentence will be. So the 2 to 3 levels in reduction is if someone takes responsibility for what they did and accepts what they did and pleads before a trial for what they did, the court gets to take that into consideration in determining what level of penalty that you're going to face. So there is that factor in federal court, and of course, depending on your personal situation and what your chances of success at trial are, that's going to very much weigh in to whether or not you want to go to trial in a federal court case or try to resolve it beforehand.
Good to know. And initially I mentioned something about you would never, theoretically, you would never want to plead guilty if you really were innocent. But is there ever an occasion that if you plead guilty, that you'd actually have an occasion to say to a judge, but I really want to explain, there were, I don't know, extenuating circumstances, or it really wasn't as it seems, and maybe they had some feeling about the principle, not just what their time served might be. Does that happen, or does it happen that the minute you say, I'm guilty, it's a open and shut case and out the door?
Part of the plea process is that the judge explains your rights to you, you sign a plea form. The prosecutor then lays out their case to the judge so that the judge has a basis for sentencing, accepting your guilty plea and sentencing you. then the judge would be able to hear from victims, if there were any, and also from the defendant. And the judge will, at the end or at some point during the process of accepting a plea, ask the defendant if they have anything to say. So if you're innocent, it's not going to be a time to declare your innocence, because you're admitting to the facts that the state is laying out to the judge. But you could explain things to the judge if you wanted to before the judge sentences you, and there may be some issue in there that the judge might want to know and hear about. But usually when you get to that point where you're entering into the sentence and the judge is going to accept your plea, there's already been an offer and you've already indicated that you're going to accept that offer. I have seen judges, though, tweak the plea a little bit one way or another based on what's been said in front of the judge, and sometimes reject the offer that's being made and not accept it, and sometimes reduce a little bit of what's being said, and the AG can then object to that. But I've seen that happen, but it's very rare. Usually it's all worked out before you get in front of the judge.
And yet, if the judge hears the person's statement or explanation, or somewhat not really a defense if you're admitting guilt, if it doesn't sound right, would the judge ever say, clearly, sir, I'm not really hearing that you are fully aware of what's going on, and that you in fact you are saying you aren't really guilty, you aren't really admitting guilt here, there's
it can,
a disconnect.
It can mess up the plea, so to speak, and the judge can say, I'm not accepting this plea based on what you're saying and what I'm hearing here. This case isn't ready for me to accept a plea, and reject it.
Good to know. And in that case, it would go to trial?
Well, there might be other opportunities to discuss it, but it could end up going to trial.
Good. Okay, good to know. And on the other side, moving forward to what you'd call, civil, if someone has a personal injury or some other kinds of case, and you're working with them, you have an opportunity to settle or go to trial. How do you help someone evaluate what the options are?
So civil cases are usually about money, and there's a lot of opportunities to settle civil cases along the way before you get to a jury trial. For example, there's arbitration, and in Superior Court in Rhode Island, there's court-annexed arbitration, which is basically a requirement for most cases before you can even get to trial. So as we may have talked about before, but arbitration is you have a mini-trial of your case in front of an arbitrator who listens to the facts and the damages and will write an award either for the plaintiff or defendant, and if it's for the plaintiff, in what they feel the right amount is. Both sides have a right to appeal that back to Superior Court for a jury trial. There's also mediation, which is an opportunity for both parties to have an independent mediator come in and listen to both sides and go back and forth trying to bring you together for a resolution. A lot of cases go to trial, and those cases that go to trial usually have some issues. I can give you the example of the first case that I ever had to go to trial on. It was a young girl who was sledding on her next-door neighbor's property, and the property was an old landfill, so to speak. It had waste all over the place. There was new snow down, and where they were sledding, where she was coming down, happened to be an old engine block sticking out of the snow. She turned the sled to miss it. She fell off and broke her leg. She went home that night. The parents had dinner. She sat on the couch, had her leg raised. Next morning, it was no better. They took her to the hospital. In fact, they found out it was broken and had to be casted. So we sued the neighbor who was having them sled there because he knew the kids were sledding there, and he knew that he had these things all over his property which presented a danger. The defense was that he didn't know that that particular engine block was there, and therefore that particular danger existed for this child, and they never offered us any money before trial because they thought it was going to be a defendant's verdict. So the case proceeds to trial. We present our case. The defense moves for a directed verdict, which is basically saying to the judge, you've heard their whole case. There is no case against us for negligence, so you should dismiss it. The judge found that there was a case the jury should decide, so he didn't issue a directed verdict, and their case went forward. So before they started their case, they came to us and they said, we'd like to settle the case, and they made a pretty good offer. So I suggested to my clients that, you know what, we've come this far, but now there's money on the table. It's time to really think about settling this case. well, there was a break at the end of the day, so they said, well, we'll go home and we'll think about it. And they came in the next morning. They said, no, we've talked it over with some friends. We've decided we've come this far along. We want to see the rest of the show. So they rejected the offer, even though I had suggested it's probably not a bad idea to settle, given, the difficulties with the case. And we finished the case, had our instructions from the judge and the closing arguments from myself and the defense attorney. And after a long deliberation, the jury came back and they found for the defendant. So my client turned to me and they said, well, how much do we get? I said, that would be zero. Afterwards, we found out why the jury found out for the defendant. And the issue was that the little girl had gone home, didn't do anything about her injury until the next morning, and they felt that maybe something happened between the time she was sledding and the next morning, and maybe it didn't happen as a result of the sledding accident.
She fell again or something?
Something. No one could really figure it out. It was not anything the defense attorney would have ever thought of or argued, or anything that I thought of or argued. It was not even part of the case. But that's the thing with juries, and that's why sometimes in civil cases, a settled case is a good case, because it's certain. There's a lot of uncertainty when you go to jury verdicts.
I suppose I need to bring this up. Most of those kinds of cases, if they're personal injury or whatever, those are taken on contingency fee, which means lawyers aren't paid unless there's money to be had. So you would have an embedded inclination to want to settle, the sure thing. Yes, you will get paid. Yes, of course, it also means that your client's getting paid. That's the guarantee that you can offer them if you settle. But how do you balance out the automatic, obvious issue, which is you settle, you have a guaranteed third or two-thirds or whatever it's going to be, versus, no, David, we really need to take this, as these people did, right to the trial?
So first of all, contingent fees are necessary in personal injury cases because very few people could afford to hire an attorney at their hourly rate to bring a case from start to finish. And the contingent fee sort of opens the courthouse doors for those people. So it's very important. The conflict that you talk about exists, but it's not really something that gets in the way of the attorney-client relationship too often, because in that case, my clients got the right to decide what to do. It's their case. I advise them. I direct the trial strategy. I put them in a position so that an offer is made, and that's my job. And my job is then to counsel them and suggest what I think would happen and how the risks are, settlement versus going to trial or to a verdict in that case. But the client has the final say. It's their case. So I don't think that the conflict is a real issue in most cases. And when it does become an issue, it's still the client's case. The attorney has a right to withdraw and let them go seek other counsel if that's what they want to do.
And they might, in fact, right at the outset, if they really didn't think that it was a worthwhile case to take from the start. At some point, suppose this is a hypothetical. Someone wants to sue and they wanted to sue for $10,000. By the time you prepare documents, prepare case, all the rest, if they even got the $10,000, actually it would be more. They would need to get more than $10,000 to get $10,000 by the time all of the rest of the fees and time lost and who knows whatever else, time lost from work. And do you go through that cost-benefit analysis step by step to help them make that decision? How do you do that?
Yes, and that's exactly part of what goes into deciding whether a case should be settled or go further in litigation. There are 3 or 4 issues that you really have to weigh and balance in litigation. From the plaintiff's side, there is what is the liability, what is the % chance that I'm going to get a jury verdict in the first place. So in a slip and fall case or that sledding accident case, you have to look at it. Is it 50-50? Is there a better chance than not that I'm going to win? You need to know that. Then what are the damages? What can I prove? So then you take those numbers and you lay them out. In a best case scenario, I might be able to get X number of dollars. In a worst case scenario, if it's not a verdict against, not in my favor, I might get a bottom line number of less. So you take that and you put it on your continuum of here's my best case and here's my percentage of getting my best case. Now when an offer is made, where does that fall on that continuum, so to speak? Is it at the lower end, the higher end, the middle? And when you have that, And you can factor in, well, after all expenses and fees and everything's paid, what do I get? What's the client's net? And for the client, that's really what the case is about. How much am I going to end up in my pocket? You figure that out. And then you can weigh and balance that against what is the time and expense of going to trial. How much is it going to cost me to bring in 4 or 5 doctors, if that's what the case requires, an expert witness to establish economic loss, whatever other experts you might have, an expert in determining whether or not there was negligence on part of the defendant. When you factor all those costs in, plus the time, plus the other issues that we have on that continuum, then you come to the conclusion, settle for this or keep going.
I guess perhaps out of left field might be other thoughts about even maybe your best witness is 90 years old and likely to be dead, so maybe you shouldn't wait till it goes to trial, or maybe the person's state of mind is likely to shift. Initially, I'm on principle, I really want you to take this to the wall, David, take this to court. Maybe in 3 months, 3 weeks, 4 months, they soften a little bit, you negotiate with, you can have them open to negotiation. So does it really change drastically for you from you putting on a trial advocacy's person's hat to, I have to find some new ways to strategize this to get to a positive outcome? It seems that there must be an awful lot of different skills that come into play if you're looking at settling something.
Well, there are. And a lot of what you need to do in a good case is to work your case up as if it has to go to trial no matter what. So that's the first step you do. The second thing is a lot of times you need to really coach your client and determine, you know, yes, we're working on this case as if it's going to trial, but they made this offer, and now it's really maybe some psychologist work of saying, you have this guarantee, I know you have this principle that you want to try, but that principle may cost you money if that's what you want to do, and you have to explain that to them. And then the final piece, of course, is the cost analysis of what's worth, you know, going forward with and what isn't, and making sure that they understand that.
And what about the idea of the principle? How do you factor that in? It's not a dollar and cents. I don't know, perhaps it isn't personal injury, maybe it's a company and its product liability, and you know the dollars and cents that might be evaluated or possibly awarded. And then there's the other overarching issue perhaps about, what about my reputation? This company does things right, David, and how do you help them factor that in the short amount of time that we have left? So
if you have a case where your client has a strong principle about something, a lot of times what they need to realize is if the defendant is putting money on the table, they're sort of acknowledging that principle, and the client needs to understand that. If it's something that they're concerned about for the safety of others, sometimes you can work something into a settlement. There was a case that James Wood had for his brother not too long ago with a medical malpractice claim, and they resolved a settlement that included some improvements to hospital procedures.
That's a good point, and of course then the company can capitalize on that.
Exactly.
That's a very good idea. We hope that this has given you some greater awareness of how to evaluate your decisions, whether they were on the criminal side or the civil side. And in case you do have to make a decision, perhaps you have some better ideas about what questions to ask. We want to thank David and Jackie, who's not here right now, Bazar, Grasso Law Firm in East Providence. Hopefully you're more aware, better prepared, and hopefully you will stay tuned to this topic and others as we invite you to email Legal Matters at legalmattersfullchanneltv.net. Stay tuned, our discussion of legal matters continues.